Hello, welcome to the channel, ladies and gentlemen. Today is going to be a bit of a wordy video. We're going to be talking about the Predator Disney original writers copyright lawsuit. I've done a few updates on this, and the previous update, as a bit of a background, regarded the latest actual sort of court hearing and the results of it. So if you don't know what this is, just to quickly explain and then get to the point of this video, because the point is actually I've had some more information from a subscriber, Dave, so thank you so much, Dave, but he posited an interesting theory that actually this could be a blessing in disguise and not a win for Disney in any way, shape or form. So if you don't know what this is, the original writers Jim and John Thomas are suing for the rights back to Hunters, their original script, and thus the Predator franchise. They are well within their right to. It crosses into that 35-year zone where copyright holders can take their IP back. They're not taking advantage of anything. It is literally the law. They're just looking to initiate that and then get the IP back. Now, what happened was there's been quite a lot of nonsense between everything. Disney waiting to the very last minute to respond, then saying that they filed it wrong, then saying that there were duplicate filings, then them doing duplicate filings, then Disney saying no, you can't have it in this certain district because actually the other district is where it should be because of X, Y, and Z. Now what happened was, because they were arguing over which court district should take the case, the judge took some time to relax and think about it and then come back with their answer. Now this isn't even starting the hearings, but the judge did come back and agreed with Disney that it should be in, I think it was the Central District if I remember rightly, court. Now I said, hey, that's probably the first big win for Disney here, but I don't think so. Now looking at it with different information, I think this could have been a blessing in disguise for Jim and John Thomas, and I'll tell you why. I will tell you why. And like I say, all of this is courtesy of a fantastic subscriber, Dave. Now, he says very specifically that the author's attorneys may have actually dodged a bullet. Now, the reason specifically for this, because the court transferring, the court actually didn't dismiss it. So they allowed for the transferal. They didn't dismiss it outright. Now that might sound, okay, well, how does that pertain to anything? Well, if Disney's argument was that the writers were forum shopping, right, bringing the suit in a court where there might be a more favourable outcome, right, many times the court would then agree with the defendant, and the court will dismiss the case with an order to refile it in the proper federal district court. So although they have obviously turned around and gone, no, you're going to be doing it in a different district here, they actually haven't said, hey, you need to refile this. So it could have happened in this case. Disney Fox could have raised the defense that the new suit is outside the 35-year limit by that point. Because what would have had to have happened if the court had sided with the defendants, which is Disney at this point in time, what would have happened would have quite simply been a case of, hey, Jim and John Thomas, you're now going to have to refile this. And then Disney can counter and go, hey, actually, they're outside of this 35-year limit now. Way outside of it, in fact. You can't, how can you restart the proceedings? So there is a certain case to be had for the fact that they've actually done pretty well out of this situation. Now again, I don't know that for a fact. This was sent to me by a subscriber. It actually makes a lot of sense, to be perfectly honest. And there was a follow-up email as well, which gave further clarification to this and said that the reason why Disney waited to the last possible second to file its initial response, because if you don't know, Disney procrastinated on this for years. Literally years. But they raised their response at the last minute and argued an invalid venue. The belief is that Disney did that to get the court to dismiss the case. So it would have to be refiled in a new court, which would then fall outside of deadline and falling outside of the sort of the legal precedent for entering into this sort of lawsuit, the copyright lawsuit. So upon first glance, and I really like this, I think this is a strong case here for this actually being the case. Now again, I don't know, I'm not a lawyer, but it's logical. It makes a lot of sense. And if you look at other situations, other filings in courts and districts and things like that, there is a precedent for the judges to go, actually no, you know what, you have kind of messed me around here. You have actually filed it in the wrong place. What we're probably going to do now is get you to completely refile it because you've messed us around. Because all that happened was Jim and John Thomas did duplicate filings under the guidance of their attorney, obviously, in the Northern District and then the Central District Court, if I remember rightly. And Disney's argument is, no, it should be held in this district court because this district court is where it falls under the initial agreement with Fox and Jim and John Thomas. Now, the counter-argument from the attorneys of Jim and John Thomas was, hey, actually, you need to put it in this court because it's going to get seen a bit quicker, it's going to get more publicity, and it's not backed up. It's not backed up by, so many cases. It'll get done quicker, which is obviously what they want. But the judge, again, sided with Disney, so it may seem, and said, no, yeah, it should go to this court. But they haven't ordered a refile. They haven't ordered that they must, file a new case, start proceedings again. They've just said, yeah, no, it will go to this court. Which could be a massive positive, because the judge, like I did say, could have just gone, okay, fine, we agree with the defendant here, refile the case. And then Disney will go, no, actually can't do that. It's outside of whatever legal limit there is, blah, blah, blah. And then have to start the whole proceedings again. A complete waste of time. So I think that again, interesting. Some people will find this interesting. This is really important. And not enough people are covering it. Why is it really important, ladies and gents? Because this will change, or has the potential to change, copyright law for anything for good. Because it was Disney that got copyright law changed the last time in terms of IPs reverting to, basically a public IP that anyone can make content with. Falls into public domain, right? It was Disney that did that. So this is huge. This is absolutely huge, and not enough people are covering it. So I wanted to cover this very specific, nitty gritty of this, very, very specific. But I do believe that actually the judge is wanting to get this to be, processed and move forward in a way which is actually a blessing in disguise. So let me know what you guys think down below. Again, I will be following this case closely. I will be giving you updates and videos and thoughts and things like that. But there you go. Cheers. Take care.